Criminal Justice, Mainstream and Cross Currents, Chapter 4, Criminal Law. This is a narrated version of this PowerPoint presentation. The development of the criminal law. The development of the criminal law was episodic, uneven, and political. The U.S. criminal justice system is a mixture of other societies' attempts to control conduct through criminal law. The Code of Hammurabi. The laws of the ancient Babylonian king Hammurabi are the earliest known written laws. The laws follow the eye for an eye philosophy. Figure 4.1 shows the timeline of historical documents and can be found in your textbook. The Magna Carta, the Great Charter, a guarantee of liberties signed by King John of England in 1215 that influenced many modern legal and constitutional principles. Common law. The common law is based on the decision of the judiciary instead of being specified by a legislature or constitution. Common law is based on the doctrine of precedent. Common law continued. Common law is sometimes called case law, judiciary law, judge-made law, customary law, unwritten law. Common law continued. Courts are generally bound by the decisions of previous courts by the doctrine of precedent or stare decisis, the doctrine under which courts adhere to legal precedent. Common law continued. 4 issues guide precedent. 1. Predictability. 2. Reliability. 3. Efficiency. And 4. Equality. Sources of law include constitutions, statutes, case laws, and administrative rules. Figure 4.2 is a hierarchy of the U.S. legal system. It can be found in your textbook. It includes at the very top the U.S. Constitution, under federal government and U.S. statutes, state governments, including constitutional statutes, local governments, and county and municipal charters. Figure 4.3, sources of law under the U.S. Constitution can be found in your textbook. It includes legislative, judiciary, and executive. Constitutions. The U.S. Constitution binds legislators, societal institutions, and the citizens to a system of government and laws. It is the will of the free people. Constitutions continued. The U.S. Constitution does not prescribe many behaviors, but sets out values that the criminal law cannot abridge. The Bill of Rights, the first 10 amendments to the Constitution, dictates the basic freedoms enjoyed by citizens. Statutes. Statute is a law enacted by a legislature. Legislative bodies have developed the common law into specific statutes prescribing criminal behavior. Statutes continued. Published in penal codes, statutes fit the principles of predictability, reliability, efficiency, and equality better than the doctrine of precedent. Case law depends on the principles of precedent and influenced by jurisdiction. Comes from previous judicial decisions. Administrative rules. Health, environment, customs, and parole agencies have the authority to enact rules that limit the freedoms of individuals within their influence. Types of law: criminal law, civil law, substance law, and procedural law. Criminal law. 3 criteria determine which behaviors are made criminal: the enforceability of the law, the effects of the law, the existence of other means to protect society against undesirable behavior. Civil law. Cases are between 2 individuals. Sentence involves money damages, not incarceration. Covers contracts, personal property, maritime law, and commercial law. Civil law continued. Tort law covers personal wrongs and damages that include libel, slander, assault, trespass, and negligence. Civil law continued. Double jeopardy does not preclude a victim from suing for private damages after the criminal trial has concluded. Substantive law, found in the criminal codes of the states and federal governments, specifies which behaviors are defined as crime. Procedural law specifies how the criminal justice system may deal with those who break the law. Specific rules of arrest, search and seizure, rights to attorneys, and attorney-client privilege. Figure 4.4 found in your textbook illustrates the difference between procedural law and substantive law. Procedural law, how? Procedural law specifies how the criminal justice system is allowed to deal with criminal offenses and sets the rules by which police and courts process cases. Procedural law protects citizens from arbitrary decision-making of criminal justice professionals by dictating how cases are handled. Procedural law specifies rules of arrest, search and seizure, right to attorneys, and attorney-client privilege. Substantive law is the what. Substantive law tells us what behaviors are defined as crimes. The substantive laws are found in the criminal codes of states and the federal government and are the result of generations of political and social development. The substantive law also sets the parameters of the punishment for each type of offense. Types of crime: felonies, misdemeanors, act-actus offenses. Felonies include incarceration is usually more than 1 year and may specify life in prison or capital punishment, considered to be the most serious types of crime. Misdemeanors, less serious offenses than felonies and subject to less severe penalties. Offenders are incarcerated in jails or stockades rather than prison. Misdemeanors versus felonies. A behavior may be a felony in one jurisdiction and a misdemeanor or not an offense at all in another. Act-actus offenses seeks to deter people from planning and attempting to break the law. Examples involve conspiracy and attempt. Features of crime. 3 elements must be present in order for an act to be labeled a criminal offense. 1. The criminal act, also called actus reus. Number 2. The criminal intent, also called mens rea. The relationship between actus reus and mens rea, which is called concurrence. Actus reus is the guilty deed, occurs when a person engages in a behavior specified by the criminal law. Mens rea is the guilty mind, present when a person acts purposely, knowingly, recklessly, or negligently. Concurrence, both actus reus and mens rea must be present at the time for a behavior to be considered a criminal offense. The exception is strict liability, responsibility for a criminal offense without intention to break the law. Strict liability, offenses in which the public's welfare is at issue. Narcotic violations, health and safety regulation, traffic violations, or sanitation violations. Criminal responsibility and criminal defense. 6 arguments can be employed in the defense against a criminal indictment. The 6 arguments are: my client did not do it, my client did it but is not responsible because he or she is insane, my client did it but has a good excuse, my client did it but has a good reason, my client did it but should be acquitted because the police or prosecution cheated, my client did it but was influenced by outside forces. Questions we can ask from this chapter: what is double jeopardy? What 3 elements must be present in order for an act to be labeled a criminal offense? And what are the first 10 amendments to the Constitution called? This concludes this chapter's narrated PowerPoint presentation.